open our second workshop on discussing various topics related to the very fashionable and very broad topic of how sustainability and competition policy issues interact with each other. Our first discussion, as you may recall, was devoted mainly to general policy issues. And now in this second chapter, we would love to have a look at a specific legal provision, what we call at European level Article 101, prohibiting and also exempting certain anti-competitive agreements, which may have an effect on trade between member states. Just like last time, we have two excellent speakers. Thanks again to Jerónimo and Yves for accepting our invitation. It's a pleasure to have you here with us. I know you have very busy schedules, so we do appreciate your presence and activity. First, I would like to ask Professor Maíllo to share his views about this fascinating topic. As you may know, Professor Maíllo is also researching topic as a Jean Monnet professor. So the floor is yours, the screen is yours.
Great, thank you very much, Tihamer. It's again a pleasure to be here in this very interesting cycle on sustainability and competition law and policy. And we will focus, as you mentioned today, in Article 101. But I would like to start with some general premises that will frame in a way our discussion. Let's use it as a reminder of the first session, but at the same time, I'm also adding some elements that will be very, very relevant, I think, for the decisions that we have to take regarding Article 101. So, no doubt that climate change and sustainability is one of the biggest challenges for humanity nowadays. And we have to be conscious of the emergency situation the European Parliament has declared it, and the seriousness of the challenge. And this, of course, means that at EU level, we have to use all tools and all EU policies to contribute to the goals, to develop the Green Pact and to be able to reach the targets at the right time. And within all those EU policies, of course, we have as well competition policy. As we discussed in the first session, it is true that competition policies is or should have just a supporting role, a complementary role, and that regulation is often a better and more important tool. We also have to take into consideration that if we are too lenient in competition, then we may have a problem, because governments may say, well, why to regulate if this can be achieved through competition policy? So they will not regulate when maybe regulation was a better means. So we should take that into consideration. And of course, we have to take into consideration as well that if we are too lenient in competition, then that may increase market power, and that may also lead to, for instance, inequality. So we should not forget this. Again, we have to take into consideration as well that competition authorities, because of their technical character or nature, are not very well placed to make very controversial political value judgments between social objectives and efficiency, and they should remain in a more technical analysis and assessment. Also important is to not forget that sustainability is a very important driver for competition. it is indeed getting, I think, more and more important. And I think we have to promote that that driver. For instance, given more transparency to the green impact of certain product or certain services, increasing the awareness of the consumer on this green impact. I think that will increase as well the role for this driver in competition. We have to pay attention, of course, not to disincentivize them for the role of competition in this side. Anyway, it is clear that to achieve the targets, we need involvement not only of governments, but also of businesses. Governments cannot do everything. It's good that business cooperate, it's good that business collaborate, and indeed, the Green Deal and also the mandate on Article 11 of the Treaty on the Functioning of the European Union encourages business to contribute as well to these goals, to these targets. The final premise I want to speak about is of course legal certainty. Business require guidelines, if possible, general guidelines. This is extremely important for business cooperation. But at the same time, we don't have a lot of experience, not yet. And therefore, it might be necessary to be cautious, and it might be necessary to study on a case-by-case basis some of the situations. So with these premises in mind, we can set the frame, the general frame, and try to start answering this question of today's seminar, which is to what extent should business be allowed to cooperate to fight climate change under Article 101 of the Treaty on the Functioning of the European Union. For instance, to what extent we should allow companies to make an agreement to phase out products and methods that will be contributing excessively to climate change, or to what extent we should allow an agreement to produce more energy efficient goods, even if that involves or that implies higher prices for consumers, or a reduction of the choice of consumers. And I think probably we get a consensus, we will get an agreement that the ideal solution will be one that allows us to distinguish clearly between genuine and proportionate pro-environmental business initiatives, which should be cleared up, but that doesn't give an excuse for collusion, or if you want to, for greenwashing. And here we shall also take into consideration that all the businesses were always complaining that they didn't have a good framework to cooperate. I see a certain degree of skepticism with regard to these complaints of businesses. Because when the Commission launched their consultation, sometimes businesses complain but didn't give real cases to the Commission, didn't show real cases, only a few of them. And that, of course, creates certain skepticism on the public authorities, and maybe also in general, about whether, which is the goal and the objective of businesses. We have to consider as well that there might be even if the initiative, the green initiative, is positive, that might have some spillovers, and they also tend to collusion of those companies later on. Anyway, it's obvious that we should look for benefits, for green benefits of business cooperation. We should take them into account. Also in the analysis of competition cases. So I think the question is not so much whether these benefits should be considered, but how to consider them. And particularly in this seminar, how to consider them in the interpretation and enforcement of Article 101. Whether we should change the interpretation of 101, of some aspects of 101, whether we should adjust that interpretation or the enforcement in order to contribute to a green society. I think this is the general frame. I hope we agree on that frame. And then we will study the options that we have within Article 101. And I will analyze mainly three options. And of course, then we have a combination of several of them. But the first option that I'm going to examine are, first, the possibility to use priorities by competition authorities. Second, the possibility of exclusion of Article 101, paragraph 1. And the third one is widening up the exemption of 101, paragraph 3. So regarding the first option, I think this is really useful because both the European Commission and after the directive, the ECN Plus directive, all national competition authorities as well have this possibility of fixing their own priorities. They can therefore investigate some cases and others they may decide not to do it. They have a big discretion, a large discretion regarding this. So this can be used for getting some of these green objectives. For instance, by more competition, not less, but more competition. Insisting on a stricter enforcement against business cooperation that is blocking or delaying green innovation, for instance, or harming competition and at the same time sustainability. And we have cases in this direction, like for instance, the diesel cases, the car emission standards cases that hamper innovation and at the same time sustainability. So if the competition authorities see one of these cases, of course, they should prioritize investigating and enforcing 101 against these corporations. And even imposing as higher fines as they should in this type of situations. Another possibility, which is maybe more controversial, is if you have a corporation that goes against genuine green business goals, and if there is a big consensus and broad social support on it, then the competition authorities, even if there is a restriction of competition, may decide not to investigate the case or to continue with the case. And that's a possibility within their discretion. Of course, we have to be conscious that even if the competition authorities do not investigate the case or do not condemn, there's always the possibility to take the case before courts, and courts will have to apply 101. But anyway, I think that might also contribute to some green objectives. Second option is the exclusion route. So the non-application of Article 101, Paragraph 1. And we have to be conscious that there are some business corporations that, because they do not relate to competition parameters, they do not fall under Article 101. And we may have, therefore, a contribution to green goals by these business corporations. For instance, promotion of consumer awareness regarding green impact, or more transparency about the green character of certain products or services, or agreements on responsible corporate conduct, or building of a database about environmental effects in a certain sector, technical investigations on those sectors. I think there's group bunch of cooperation agreements that may not fall under Article 101, Paragraph 1. The second possibility will be using the case law on Wouters and Meca Medina. Obviously, these cases so that we can exclude from Article 101, Paragraph 1, some agreements if they have a legitimate interest. The restrictive effect on competition is inherent to that legitimate interest, and of course, provided that the conduct passes the proportionality test. My doubts here are, why only the environment? Why only climate change and not other public interest goals? And to what extent this should prevail? It's true that we have the proportionality test, but I have certain doubts regarding the use of these means. Another interesting way of excluding the business corporation under Article 101, Paragraph 1, is using the case law on Kunst en Informatie en Media versus the Netherlands. This case excluded from Article 101, Paragraph 1, collective bargaining between employers and employees intended to improve employment and working conditions. And I wonder whether it is not possible, therefore, to do something similar regarding green goals, excluding agreements that contribute to improve sustainability and which count with a strong consensus and participation of stakeholders, not only producers and employers, but also consumers and NGOs. Or we may use a combination of some of the means that were previously analyzed. Which is the advantages of this option, this second option? Of course, that we don't need to do cost benefits analysis. And the risk or the problem is that we will need, at the very end, we will need judicial validation by the Court of Justice, because we will be applying it by analogy. And we don't know if the court will be open to extend Wouters, Meca Medina, or to extend the other case law to this field. So there is always a risk, but I don't think we will last a lot, probably, to see a case be brought before the Court of Justice in this regard. The third option is the exemption route of Article 101, Paragraph 3. And of course, it will go in the sense of widening through a reinterpretation of some of the conditions of the exemption. And I have listed some of the possibilities that we may discuss later on in the debate. One possibility will be to give more importance to non-price efficiencies, to qualitative efficiencies. Of course, the problem here is how you quantify those, but it's true that environmental economics have made a good job in this regard, and there are methods to quantify these qualitative efficiencies, these environmental efficiencies. So that's one possibility. Second one is reflecting on the time frame, not taking into consideration only short term, but also taking into consideration medium and long term, and therefore to do a more dynamic assessment, even more dynamic than nowadays, giving more importance to those dynamics instead of just a static assessment. The third possibility will be widening when an in-market efficiency exists, taking into consideration not only direct impacts, but also indirect impacts. And of course, you may widen what an indirect impact is. So that might be another possibility. A much more controversial means is to take into consideration as well out-of-market efficiencies, or at least partially, and of course collective benefits for the society in general, not applicable directly to the market, to the relevant market, but more generally to the public interest of the society. And this is very controversial, of course, because then where you stop, to what extent you can do that, maybe it's more feasible to think about partially using this out-of-market efficiency. So cases in which you have a direct impact on the relevant market, and as a complement, you take into consideration also out-of-market efficiencies. That might be more admissible. Still, it is controversial. I think this will be probably the most controversial issue of the list. Finally, I think we can also reflect on other two conditions, not on the first one to apply the exemption efficiencies, but on whether there is a fair share to consumer, or whether the restriction is indispensable to obtain the efficiencies. What is a fair share to consumers? I mean, we may also widen this by not taking into consideration only individual use value benefits, but also non-use value individual benefits. The consumer is willing to pay more, or even other externalities. So that will also facilitate the application of the exemption. And the third condition, regarding the third condition, indispensability, I think it would be admissible to consider that urgency, there is an emergency, climate change is an emergency. Urgency might make indispensable certain conducts that in the past were not. And we have to be very conscious that we have to get these targets very quickly, and that sometimes it is very important for this speediness, the first mover And if the first mover has a clear disadvantage, it might be necessary to cooperate to eliminate that disadvantage. So this enters into the discussion of whether the conduct is indispensable or not. But you have here a quite wide list of possibilities to reinterpret and widen the exception. And without, taking all of them, there is a possibility to increase and to widen the applicability of the exception. Well, I would like to conclude with some final remarks, and this go in the sense of answering this question: how to manage all these options. The first thing I would like to highlight is that there is a possibility, of course, to combine several of them. Priority and cooperation not related to competition parameters. This is easy to apply, and I don't see any problem for the application. More difficult or more, I think we have to be more cautious on exclusions of 101 paragraph 1, and of course on the flexibilization or reinterpretation of article 101 paragraph 3. And whenever we widen these possibilities, we have to reflect first on the general impact of these and the spillovers on the cases and the control of other conducts. Finally, business will need general guidance, that's for sure. And I'm sure the European Commission is or will provide this guidance to business through the horizontal block extension regulation, the reform horizontal block extension regulation, and the horizontal guidelines. However, I think because there is no yet a lot of experience, probably that general guidance will be limited. And then we will have to complement that general guidance with some other techniques. And I think we should go for possibility of ex-ante consultation of the companies in specific cases. Maybe looking as well if there is a consensus of stakeholders. Those cases will be under strict supervision of the competition authorities regarding times, conditions, exposed reporting. I think this will be a way to acquire experience, and we should also find a way to communicate that experience progressively to the general business community as well, so that more guidance is provided to them as soon as possible. And that's all. Thank you very much.
Thank you, Jerónimo, for your usual extraordinary summary of all these potential theoretical ideas how to approach this problem. I had a short informal discussion in the background with Yves, and as far as I know, Yves is going to address mainly a topic related to associations and various industrial coalitions. So now I propose to let's devote some time to discussing some ideas raised by Jerónimo. But if your question specifically relates to associations, then please save it for the second Q&A time slot, if I could ask you. It was very exciting indeed. So nice time for you to pose your questions, comments. Before you consider your questions, I just have one, partly a note and a question to Jerónimo. the big question could be something like this, that who should be in the driving seat? I mean, institutionally speaking, now when we are discussing, new ways of thinking, what shall we do with these issues? It just occurred to me because your slides, when you were considering the non-application of paragraph 1, so basically public interest related exclusions from the scope of competition rules, it's just obvious that all these cases came from national procedures, which finally arrived at the table of the European Court of Justice. So these were preliminary rulings where the court was the brave guy and was experimenting with the boundaries of competition law. And I'm just wondering whether we could ever expect such an approach from the European Commission, being the competition authority, eager to have cases, apply competition law, which of course would require a broad potential intervention for this institution. And at the same time, we also see, you mentioned, and I also put on the comment box, chat box, a document from the Hungarian Competition Authority, which was prepared for the last year's ICN conference, summarizing mainly statistically how active competition authorities are in this topic worldwide. And there, if you can see it, and also from other sources, you can see that in some cases, national competition authorities are more active than the European Commission. Like, the Dutch, the Greek competition office, just to mention the European ones. They have already issued guidelines. So they have a kind of first mover advantage. So it's a very complex topic, I believe, that who should be in the driving seat, ideally.
Well, ideally, I would say that the European Commission and the Court of Justice, of course, should be the driving seat. But that does not exclude competition authorities, national competition authorities, as we have seen. I mean, what is important is that at the very end, we get a certain consensus at the European level about it. How we build that consensus might be up down or down up. We may start with the debate at national level and national competition authorities decide in some cases, issuing some general guidance, and then of course there will be an interaction with the European Commission, and the European Commission will develop and discuss these possibilities and adopt its own position. And the cases, of course, may also reach the Court of Justice, and then the Court of Justice will definitely set some issues. But I mean, it will not be bad, I think, that sometimes the European Commission takes the initiative. I mean, even risking takes some positions, even if that is challenged then before the Court of Justice. Or I will say that this will diminish asymmetries and will contribute to a quick clarification of the law and of the possibilities. So I will request the Commission to be proactive in this sense, and not just wait for the national competition authorities to act.
Thank you.
Well, if I may, I had a question, because I think your the three options is a very interesting approach. I think there is a dimension connected to the burden of proof and the allocation of the burden of proof. And if we take that 101.1 is really on the shoulders of the authorities and complainants to demonstrate that there is an anti-competitive agreement. On the other hand, when efficiencies are being pushed to counterbalance the anti-competitive effect, it's largely put on the shoulders of the defendant. Now, I don't want to go into the Intel case that was recently published by the court, but it's an interesting piece that it's an allocation of the burden of proof, and I wonder whether in this particular debate, when companies are pushing on certain efficiencies, when does it shift back to the authority or the complainants to say, well, I hear you about the efficiencies, but they're not enough because blah blah blah. And so the question is, should there not be also part of the thinking about what is the standard of proof? That is, how far you have to go in terms of establishing the test, the relevant test under the under EU competition law, and then the allocation in the burden of proof, and whether reforms or new thinking is needed in that regard.
I totally agree, and thanks for bringing the point that the burden of proof and the possibilities to sift the burden of proof may play a very important role as well in this field. Business always, of course, complain that first that there are a lot of restrictions by object, in the opinion of the European Commission, sometimes as well the court, and then that once there is a restriction by object, or there is a restriction, sometimes it's very difficult to apply the exemption because of precisely the burden of proof. So I think playing with this burden of proof is possible as well to give more room to appreciate green initiatives. No doubt you are right. How and when? That's more difficult, of course. But I see. When I was reflecting on 101 paragraph 1, for instance, and the possibility to use a combined approach of Guterres, Mecca Medina, and the case law on collective bargaining, I wonder whether it would be possible for the companies at that stage, still under paragraph 1, to show that there is a legitimate interest, that it is proportionate, and that there is a broad consensus of all the stakeholders. And whether, if the companies prove that, whether then the competition authority may decide to exclude 101, paragraph 1, or without finally deciding the case, just leave it and stop the investigation or stop the proceeding using its priority possibility. And this will be playing with the burden of proof as well, in a way, obliging the competition authority to prove their restrictive effects, but at the same time giving the companies within paragraph 1 of Article 101 this possibility. I don't know what you think about it.
No, it's very interesting because your third option, which is really a revisiting Article 101.3, in my mind, is really looking at the standard of proof, how much evidence or what evidence would satisfy the test that it is more efficiency enhancing than anti-competitive, given a certain agreement. But it's also a question of shifting the burden of proof. That is, when do we see sufficient evidence being adduced and sufficiently cogent and convincing to then push back on the authority and say, hang on for a second, what we are doing actually is pursuing those goals, and we have all of these elements showing that it's, beneficial to consumers, to society at large, that this is indispensable, blah, blah, blah. I think this is really not necessarily a revolution, but a need for these authorities to actually dare to delve into 101.3 in ways, as you said, that they've not necessarily been doing before. Satisfying themselves and saying, oh, it's 101.1 is satisfied, I don't need to take a look at the rest, it's sufficiently clear that it's anti-competitive. And that's the temptation of authorities to do that, right? They're looking for the easy case, the one that they can close quickly, where they can impose fines and go public and say, hey, see what we are doing, we're a super great authority. So it's a little bit of change in mentality as well in the way authorities are approaching cases.
Yeah, I think we have to accept that the analysis, the assessment might be more complex, and that we should need more data, more tools. But if we want to introduce it, this side, this element of environmental considerations, environmental efficiencies, I mean, we have to accept that the analysis will be more complex. In many cases, it will be case by case. So it's a bit what happened with the more economic approach to competition cases. This, I think, may go in the same line. And it has, of course, pros and cons, but we have to do it if we want to integrate them and do it in a proper way, in an objective way, without discretion, or without large discretion, I think. So I think we should move in that direction.
Maybe just one more comment to this complex issue, that maybe that's one field where we can really see where we can see the negative consequences of the past 20 or so years, when most competition authorities in Europe just became reluctant to take on complex cases. Everyone was aiming for the easy win, let's go against cartels, and we just don't have, not even case law, we don't have experience, administrative experience. And to be honest, I really don't like those guidelines which are not backed by cases. This is very ideological, very experimental, and yeah, that's the downside of not having cases.
So, I will move relatively quickly here because this has already been covered. Clearly, competition is there to play more of a supporting role and not a leading role in this debate on sustainability. Clearly, regulation, tax policies of the member states will definitely be playing a much more prominent role in fostering innovation and getting people to change conduct in order to meet those goals. I think what I wanted to touch base on is really where does the industry stand, at least interacting with trade coalitions, trade associations, and various industries. It's, to your point, Jerónimo, there is not much knowledge about an understanding as to how far these people can go. And what sorts of instruments they can put in place at their level jointly without infringing competition law. And I think part of the interesting debates that we're going through with some of these coalitions and trade associations is, and we met some philosophy, and they're frail in terms of, oh, we don't want to do this because one of our members told us it would be anti-competitive. And so competition law today is still very much seen as something that is, evil and risky, and people are very cautious about engaging in joint initiatives. And part of the reason maybe, and that's maybe, you know, our responsibility as advisors and lawyers, that sometimes, you know, colleagues and ourselves are maybe too cautious in approaching some of these issues and not daring enough to say, let's go the extra mile in analysis and pushing the envelope to go a little bit more into details of an Article 101.3 analysis. Now, there is at the same time a recognition, and it's relatively nascent at the European Commission, that there is a role to play. Clearly, the Commission is probably playing catch up, and that's not surprising because, you know, we are 27 member states and different views, different cultures, different approaches to antitrust law. And so perhaps the European Commission is a little bit there to try to find the common denominator to this debate. You will have seen that indeed the Dutch and the Greeks have taken the lead, and, you know, Jerónimo already alluded to that. You know, DG Comp is, you know, is working on its horizontal guidelines, and we are hopeful that we will see soon a proposal coming out of DG Comp touching indeed on sustainability from a horizontal standpoint. Now, looking at industry coalitions, I think clearly there is pressure on industry to deliver. And I would think that there are two key concepts. You know, one is about transparency and accountability. You know, there is expectations on the part of the public, and that may be coming from, you know, social networks and the new internet economy, for more transparency on what's going on at the industry level. How are they fulfilling their duties? You know, people have seen greenwashing, and so they expect now industry to be a little bit more open and transparent about how it does things. And accountability, meaning, you know, you claim that you're going to do this, you know, you claim that you're going to sunset a number of technologies that are particularly polluting or particularly harmful to the climate. Show us how you're going about it. Show us not only the direction of travel, but what are the endpoints. And so industry is under pressure to show that indeed they are meeting a number of goals. And so there is a reportability, you know, there is a reporting that is expected, and I'll get back to that point in a moment. I think another piece to it is, and in debates about do we build or shall we do things in an industry coalition versus acting individually, clearly there is a trade-off. And clearly we see debates at the level of trade associations or coalitions saying, do we have a role to play for the industry? Or is there expectations that we take the lead on a particular debate? As you see, so far what we've seen in the debate is, on the one hand, phasing out harmful products and processes, and working to introduce new products, new technology, new processes that are cleaner. So that's what we see in terms of initiatives. And in those initiatives, and that's an important parameter for antitrust analysis, you know, the question will be, do we work within the framework of a regulation or legislation that mandates us to adopt new processes or new technologies and phasing out certain products and processes? Or are we going beyond what the law currently says? That is, we are proactively engaging into a more ambitious journey. And indeed, the regulator is basically going to be trailing behind adopting legislation that, you know, basically endorse what we have been doing. And what we see in that area is that, you know, the Commission has been particularly suspicious of situations where industry preempt legislation or acts more proactively, either to indeed, you know, preempt the European Parliament in taking initiatives, or goes beyond what the law currently says. And I think this is important to think about it because you know, in our discussions with some of the Commission officials, they say, we are more suspicious in this second scenario. I think another twist to thinking about the risk and you know, the path or the journey towards you know, fulfilling climate change and biodiversity goals is clearly that in the initial phase of a debate at industry level, what you will often see is let's do it poco a poco. That is, let's start with loose commitments, and they're all voluntary. We don't want to oblige anyone to do anything. We just are setting out, you know, recommendations, putting a best practice code, and then gradually what you see in a dynamic way is as they go through, you know, an iterative process, they say, now that we have set a relatively loose document, now let's go the extra mile by putting something a little bit more ambitious. In other words, more constrained. And so clearly, when you talk to industry, they say, "Oh, Yves, that's very interesting. You're talking about standardization from the get-go." And I say, yes, I do, because not only this is the only framework we have in the horizontal guidelines, or EU competition law is really associating all of these industry initiatives under the lens of standards, but it's because I very well see that at the end of the day, this is where you're going to end up doing. You know, you say today that you don't want to do that it's too early, but ultimately this is where we are going to end up with, i.e., you know, standards with labeling, certifications, and so on and so forth. And so what you see is very much on this slide, the direction of travel. So, you know, when we start the discussion, it's issue sensing at the level of a coalition. Then people are sharing their experiences. You know, member companies are saying, hey, this is how we do this is how we do that, blah, blah, blah. And then clearly there is a little bit of a you know, what we want to understand is what is our current baseline? Where are we? You know, where is the industry today? And so this is where we engage into information exchange. And this is where, from an antitrust perspective, we start to have, oh, are we sharing pre-competitive information? Are we sharing sensitive data? So that's where we really need to put a framework for engaging into those kinds of things, which of course creates some delay. And, you know, lawyers are going to say, yes, there is a way to do it, but you have to go through various frameworks in order to make sure you're safe. And then it's identifying, you know, do we do things together? And if so, what are we going to do? And that's the blue circle. And then, of course, once you agree on you know, I would say a deliverable, it may well be best practices, a code of conduct or standard, then clearly, very quickly, over time, people are going to say, that's all fine to have a document that shows the industry ambition, but the world expects us to do something more tangible. They want to see concrete results. And so that's where you gradually move into, you know, KPIs, where, you know, you have to show benchmarks that are being reached by the industry as a whole. And that's where, again, information exchange comes into play. And that's where, again, there is an agreement on what is, you know, how are you going to define the KPIs? What are going to be the relevant data you're going to collect at each member level? And so at the end of the day, what data, how you're going to share data, which ultimately may well then become more competitive because sustainability becomes a marketing tool, becomes something that is differentiating. And so indeed that becomes a little bit where, as an advisor, you need to also accompany the data collection and the data exchange. And then ultimately is what do we tell the world and how? And so that's the monitoring and the regular reporting about the industry initiatives. So it's just to show you in a nutshell a journey, and sometimes this journey, as far as I can see, have sometimes been taking quite a few years. Why is that so? Because industry is very conservative, and those industries that precisely have to do the sustainability journey have often been very much hammered by cartel violations. Chemicals, energy, are all industries that were prone to and have been subject to enforcement in the past. So this is just here summarizing what I just told you. But I think in terms of thinking about the industry initiative, very much along the lines of what Jerónimo said about his third option, is thinking first and foremost from a practical standpoint about what's the efficiency, what's the good guy story, in other words. And I think what we tend to think about, and what I've heard, and is really pregnant, and so I really relate to what Jerónimo said earlier, is that the reason sometimes people say we need to move together is not only to show that the industry is really progressing as a whole, but it's really to avoid a first mover disadvantage piece and say, if I am to, as a one industry, one company, if I have to engage into significant costs to clean up my supply chain, or buy or develop a new process that is going to be less CO2 emitting, I don't want to be the only one doing it and losing market shares because my products are more pricey. And so there is also this idea of first mover disadvantage and creating a level playing field. And you see that, at least this is my experience, and I would be very interesting to hear what you have heard and how you have been interacting with those kinds of issues. But clearly this is something that I've seen quite often in the initial discussions with coalitions. And of course, once you think about the efficiencies and developing an efficiency story, is look at the coordinated effects and look at the way things are being created and set up and say, is it necessary for us to frame or organize the initiative in this way? Can we find something that is less restrictive in terms of choice, innovation, but also softening competition by exchanging too much information? So that's going to be something that we'll be looking at very, very attentively. And of course, as we think about the initiatives along the lines of codes of conduct morphing into standards, the more inclusive, the more open, and the more you give opportunities for stakeholders to provide input, not only those who are part of the coalition at the same level of trade, but also vertically, that is upstream and downstream. The more you involve the whole chain of supply, the more likely that this is going to be seen and viewed positively by an antitrust authority. So there is a lot of questions about how do you do it in a way that doesn't raise concerns, and then the content, how you do it, and that is how do you put together the initiative and what it means in terms of restraints that are imposed on the supply chain. So I'm going to pass on this one. You probably have heard about this one. Another piece that we see and that we've been working on is the control of the supply chain. This is something that you have seen earlier this week, Wednesday. The Commission came out with its proposed legislation on corporate due diligence, devoir de vigilance, clearly heavily inspired from national initiatives, from the French devoir de vigilance legislation. And clearly what it means is this is yet a new case where companies of a certain size will have to audit their supply chain. They will have to seek data and information all the way up into the supply chain. They will create new source of supply. They will shed suppliers. And so indeed, they will impose new standards. And so what we see is that not only there is standardization, but we see scope for engaging into boycotts, information sharing, alignment of cost and prices. So again, an area that is emerging where we see that the duty of vigilance has to be conducted indeed individually by each individual company, but clearly there will, and we've seen that there is a role to play industry-wide for setting the tone on the way this is going to be carried out. So we touched upon Article 101, standardization, information exchange, managing the supply chain. And the last piece that I wanted to just briefly touch upon with you is joint ventures. So R&D joint ventures, production joint ventures. When you put a standard or code of conduct, when you clean up your supply chain, that's one thing. But ultimately, other tools that are available for companies is to join forces to reach scale, and to move faster, and also to take advantage of complementarities between various industry players. And that's where we see, joint ventures being one of the options taken by industry. Now, the question is, what is good for the environment isn't necessarily good for competition, and that's where there is a question mark. Often we will see that there is value in doing things together. But clearly, there are risks that can be associated with joint ventures. And perhaps what I wanted to do is to briefly show you this table. Clearly, what we see emerging today is new technologies. Take hydrogen, for instance, is really clearly an area where a lot of people are investing, early phase, early development, clearly working through pilots, creation of the necessary infrastructure, where allegedly you're not going to be into a full function joint venture, and so not reportable under the merger control rules in most countries, except of course Germany and Poland. But and then you have the justification. Why are we doing this? Scale, reaching visibility, credibility, acceleration of the development, sharing the risk. So that, as an industry, not everybody is positioned similarly in terms of risk and exposure to the financial markets. And so indeed comes up the question of competitive impact. And you see there some of the questions that would be part of the 101.3 analysis. New market infancy, new application. What's the state of the market power? What is the market affectation of what of the companies being involved in the initiative? And then, of course, looking at the green efficiencies. So I wanted to close this and open for debate with those short considerations. Thank you.
Mm-hmm. Excellent. Thank you, Yves. It was much more than just a few short considerations. I'm pretty sure we agree on that with the audience. Thank you for these practical examples indeed. Yeah. So what we are discussing is not merely theoretical, making us academics excited, but also very practical, making legal advisors, business people concerned about these various positions. So any questions, comments to what Yves has just discussed with us?
Maybe if I will ask you about the inclusiveness and the participation and involvement of other stakeholders in the business initiatives and the development of those business initiatives, because this is very much linked with the case on collective bargaining that I mentioned before. And therefore, the possibility of excluding the application of Article 101, paragraph 1 to some cases. And for sure, I think that even if that's not the case, whether there is inclusiveness and agreement, broad consensus with other stakeholders, I'm sure is taken into account by competition authorities also within paragraph 3 at the very end. Maybe in an indirect way, but I'm sure that they will be taking this into account. So two questions with regard to this. First, do you agree that competition authorities nowadays are considering this and are taking this into account? That it has an impact on the decision of the competition authority? And second is which level of inclusiveness and participation of stakeholders is needed for the competition authorities?
Yeah. But it's good point. I mean, clearly, my inclusiveness point is really drawn up from the horizontal guidelines on standardization. And, you know, the guidelines basically say that if you fulfill such and such and such conditions, and, you know, the standard has to be voluntary, it's open to everyone, you know, it's sufficiently, doesn't exclude technology, it's not mandatory and blah, blah, blah. Then you know, unlikely that it falls within Article 1011. So, but the thing is that the world is not that simple. And so when we come to advise companies and their coalitions, what is interesting is that there is always an efficiency trade-off. That is, the more people you involve in a debate, the larger the group, and plus if you add the supply chain upstream, downstream, then it becomes extremely difficult to generate consensus as to the direction of travel. What are we going to do? What sort of standard are we going to put together? And particularly, there is a trade-off between indeed efficiency, speed, and also, you know, I would say, quote unquote, democracy. The more you open the debate, the more you're likely to be, you know, to be dragged into all sorts of interest coming upstream, downstream, and those who are not party to the consortium. And so ultimately what we end up doing is, you know, working with smaller circles of companies, and it's usually, you know, what I qualify as coalition of the willing, who are prepared to take the lead. And then the question will be, how do we make such that we are sufficiently public, we are sufficiently open vis-a-vis the outside world and vis-a-vis non-member coalitions to allow for them to contribute at certain, you know, touch points or certain, you know, certain stages in the process, knowing that ultimately we keep the hand on how we are going to formalize the standard or formalize the, you know, the goal, you know, how we're going to translate in practice the goal that we have set. And so I think this is really ultimately the issue that we are often very much confronted with is, yes, the more you open, the more you are, the better the more safe you are, but it's always gray. And it's, you know, it's probably 50 shades of gray, but sometimes you're in dark gray versus light gray. Does that respond to the point?
Yeah, of course, of course. It is also true that the less open you are, the more probably there will be suspicions by competition authorities that you may be partial. Yeah. You may be disregarding certain perceptions, certain views. The more you control the final outcome, the more, of course, the competition authorities will tend to think, well, this might be partial. So I perfectly understand this trade-off and how complex it is to apply it to specific cases, which at the very end is yes, we have this case law, we can use this case law, but in practice, it's extremely complex.
Yeah.
And it's not only the process, it's at the end that you have a broad consensus by all stakeholders, even upstream and downstream, on your final outcome. So it's the process and the outcome, I think.
Yes, absolutely. And look, I very much, you know, relate to what you were saying earlier. That is, you know, there is hardly any case law, very few. You know, I was looking at this morning at the OECD submission that was very well crafted, that was submitted in the context of the, you know, the Commission's consultation. There is not much case law, quite frankly. You know, we have the chickens of tomorrow, we have the Daimler, you know, the scandal, that's, you know, the case that was on my slide on the car emission scandal, the Dieselgate. But the thing is, you know, the Commission has hardly any experience. And I think one of the part of the debate that is very interesting is that the Dutch have shown a very, you know, they're very open. They say, look, come and see us, talk to us. We would like to learn about, you know, the kinds of things you do. And I think the problem with the Commission is that they would like to learn more about cases. They would like to perfect their understanding. But, you know, we are very afraid. We say, look, go to the Commission, talk to them, open up about the kinds of things you want to do. And then they will say, oh, it's illegal, we're opening a case. So it's where we sense that there is probably at the level of DG Comp some evolution in their thinking, recognizing that it's probably needed to have a more you know, a more open door policy and more lenient approach towards people coming forward to say, hey, we want to do something, we want to test it with you. How do, you know, if we do it in this way, what's your reaction? So, and indeed, you know, Regulation 1/2003 provided for sort of, you know, letter of comfort and so on, but it has been hardly used. And I think this is where, you know, you know, we have been very strong advocates for the Commission to be far more open and far more engaging. This is happening, but I think it's a slow process.
Yeah, I think we can fully agree on that. Let's push the Commission for more comfort letters. Let's start a new movement. Green one, obviously. Anyone else from the audience with comments, questions? Maybe I just have one interesting case for you to mention quickly. I read about that when I had a look at the Hungarian Competition Office you know, ICN related sustainability document. And there was one case referred by the Hungarians as which had some link with this topic. And that was an interesting decision adopted 3 years ago. It discovered the cartel, punished the cartel between Energizer, Duracell and Varta batteries producers. And what they did was that about 10 years before that time, they had agreed that they would pass the so-called waste management fee, you know, which was a government tax-related regulation put on these companies. So they agreed to pass this over to their customers. And so it's a short story. And what I was just wondering that from a mainstream cartel perspective, that's an obvious case. Maybe a little bit stupid case, so why do they need to agree on that kind of natural thing? Most companies would pass, you know, this cost increase anyway to customers. Well, what they agreed on that, so it's an obvious case, you can't really defend it. But if I'm just wondering that if you take into account sustainability, then was this agreement clearly anti-competitive, but was it really not in line what the government had intended to do? I mean, making these batteries more expensive and thereby reducing their consumption, reducing the stress on the environment, so on and so forth. I think this argument was not raised in that case, to my best knowledge. It's just maybe an interesting proposition. I don't know how you would see it. And of course, it raised the very basic question, so how far we are committed to stick with very old price increase dogma around which competition law is built nowadays. So whenever there is a risk of, you know, price increases, then we should have that agreement. So whereas sustainability would in many cases require, you know, higher prices, better quality, longer durability of products coming with higher prices. So there can be a very interesting tension here between these various goal aims. Well, maybe if you have any comments on that. maybe I'm very bad, frameworking or phrasing this question, but well, if not, then all is left to me to say thanks to you for taking the time to participate, to contribute to this discussion. It was very interesting to me. I can say that. I also hope that the audience would share this view. And yeah, maybe next time we may come back with new topics, maybe greenwashing, misleading advertising, and state aid cases a little bit. But okay, that was for today. So thank you very much, Yves and Jerónimo, for your excellent presentations.
Thank you very much.
Thank you very
It was nice
much.
to be with you.
Bye.